Hi guys, it's Kathy. I hope you're doing well. We made it to Thursday. Yay. Thursday is the mental health docket in one of the courts in Colorado. So, those are always good for members only clips. They're not great for everybody, but they're good for members only. So, if we get something, I might do a members today if it's good enough. So, we'll see. We'll see what happens. It won't be until way later, if anything happens at all. And we don't know yet because court hasn't even opened, but courts are opening soon. Yeah, Kinsley, where's your dad? Karma. Karma, guys. People who wish for karma on other people, there's kind of people, nah. Let's go to, I'm pretty sure this is Colorado. I just don't know which county. No idea which county.
Deaver, Jet Deaver, 25 CR 384.
Hello.
Your name, please, sir?
Chet Deaver.
All right. Sir, did you watch the video advisement of your rights?
Darn it, Raven.
Yes.
You have any questions about that?
No.
All right. The charge in your case is one count of assault in the second degree. That's class 4 felony. Possible penalties are up on the chart there. Any question about the charge or the possible penalties?
No, sir.
All right. All right. Bucking Bud is 10,000 people.
Yes, Your Honor. As far as reason of PC affidavit, we do have elevated fear for the victims in this case, especially with the acts of strangulation. So we believe a casualty property bond will be appropriate here in order due to the danger to the community and to the victims that the defendant poses. We do note there is a lack of criminal history in Colorado, but it seems to be he's only recently moved here. I think there's a longer history of his time.
Everybody look at this. Your Honor, I'm innocent, says the total serial killer right below me. Innocent.
That's possibly in Montana, and so it seems it might be a lack of ties to this community, and so I believe there is a higher likelihood that he would not be compelled to show to court with that situation. So I believe casualty property be appropriate here.
All right. Defense.
Yes, Your Honor, I would ask for a supervised PR bond in this case. I would note that pretrial services, in other cases, I have seen them indicate that there's out of state criminal history, but they didn't. They said that case history was found, and that is consistent also with my searches. So I think given that there's no criminal history, and then the CPAT score from pretrial services is as low as 3. And so I think that just indicates that he's not a danger to the community at this time. And then I would also just note that he did indicate that he's unemployed at the time. So just any amount of bond would be equivalent to a no bond hold in this case.
The perfect video that I can get of court for everybody would be JK is the lawyer and Raven is the defendant. No, JK is the prosecutor and Raven pro se is the defendant.
Given that he has limited financial means. And so given that this is the first offense, I would ask for a supervised PR bond.
PR bond. Your Honor, can I get a supervised beyond bond? Yes, let me. I'm stressed.
That's what I'm trying to decide right now.
You'll be jury, Kelly. You'll be the head juryman. What do they call him? Come on, give me the words. How many court cases have I watched? The foreman. You be the jury foreman. Yeah, thanks, Monica. I struggle sometimes. Getting old sucks. Micah would be the judge because he understands rules. And he knows which rules are bad and which rules are good and how to use them for people.
Yeah.
Or he could work in the cafeteria making sandwiches.
Is the screen frozen?
No, sir, I'm reading.
Yeah, my bad, I apologize.
Court has reviewed the PC affidavit. I will note the booking bond is $10,000. That's the standard on a felony for private violence. I mean, there are obviously some other issues at play here. But the people who work at this facility have a right to be protected and not be assaulted. They're there to try and help people.
I understand that.
And so I'm not going to set it at 10, but I'm also not going to grant a PR. I'm going to set it at 3,000 cash surety property.
Oh, what does property that do?
Well, if you have property, you can put it up to post your bail.
Oh, I haven't got anything. Okay.
Okay, next court date.
February 5th at 1:30 p.m. in Division DST.
Okay, thank you. People versus Frey.
Yes, Lori, you're the bailiff with 2 tasers. Oh no, we're all in trouble. Okay. This next one. Let's go to New Jersey for 3 minutes. Remember, the audio in New Jersey is not great. It's only 3 minutes though, don't worry.
After the next one?
Yeah, I'm gonna do the next one and then I need Miss Padilla back.
Okay.
What is your name, please?
Davion Edwards.
Thank you. And what's your address? I'm sorry? City, state, zip.
Patterson, New Jersey, 07522.
Thank you. This is Central Judicial Processing. This is your first appearance. I'm going to advise you of your charges and your rights. You were charged on W25413 with 2C292A, resisting arrest, a disorderly person offense, 2C182A, burglary, a crime of the third degree, and 2C291A, obstructing the administration of law, a crime of the fourth degree. You should have been provided with a copy of the charges. If you weren't, you'll get that by the end of the day. Do you understand?
Yes.
You have been found eligible for the public defender. Mr. Rohr?
Bill Rohr, public defender. We enter plea of not guilty.
Thank you. Prosecutor?
Your Honor, the state filed for detention today at 10:53 a.m.
Thank you. Sir, the prosecutor's office filed a motion for your pretrial detention. What that means is that you are not going to be released today. However, you have the right to a hearing of that decision, which must occur very quickly. And that hearing has already been set for this Thursday, February 6th, 9 a.m. before Judge Romana. Do you understand?
Yes.
Now, since you're being detained, I have two questions for you. Do you have any children under the age of 18 that require us to send Child Protective Services because you're being detained?
I have children, but they with their mother.
So that you don't need Child Protective Services, correct?
No.
No?
No.
Okay. Are you the guardian or co-guardian of an incapacitated adult that requires adult protective services because you're being detained?
No.
All right. Do you have
He seemed annoyed to even be asked. I ain't taking care of no adult. No. Heck no. I can't even take care of myself.
any questions?
They said I was going to be released. What happened?
The prosecutor's office made a motion to detain you, and now that's what's going to happen until your hearing on Thursday.
Okay, so I'm being detained until my hearing.
Correct.
So I will be, to make this clear, I will be released my next hearing.
Absolutely not. I did not say that. What I said was there's going to be a hearing on Thursday. The public defender will represent you at that hearing. I'm sure they're going to ask that you be released. Judge Romana will listen to both sides and make a decision. But that decision has not been made yet because there's been no application yet. That will be decided Thursday morning.
Okay.
So right now, the only question is today, are you being released or not? Because the prosecutor's office filed that motion, you can't be released, but you have the right to a hearing and it must be heard no later than Thursday. It's Thursday at 9 a.m.
Okay.
Okay? Any other questions, sir?
No, don't.
All right. You'll speak to your public defender assigned to your case before that hearing. Good luck to you.
Okay.
But listen, I committed a crime, but I want a PR. I want to be out there. You can't get us. This is against the law to keep me locked up like this. Judge, this next guy, it's very conflicting.
2204F208. And
This is Indiana. I'm putting up because Indiana is up, even though I'm in Pennsylvania.
Mr. Harlan, Mr. Head, have we seen a copy of the BSI?
Have you looked at that? Any changes or errors, or corrections or anything?
All right, David,
We have taken a plea on Mr. Head's cases for just 3%.
remember that because that was a lot of charges, so
Yes, we all remember that.
yeah. So, Ms. Castleman, what's the state's recommendation on the sentence today? This was blind, right?
Yes.
Judge, it is my understanding, and please correct me if I'm wrong, of course. It is my understanding that we're pleading blind to a level 2 with no cap. With that being said, I would have to ask for that maximum for the level 2 to be executed. Part of the reasoning for this is I'm showing that Mr. Head does have 10 prior misdemeanor convictions and 10 prior felony convictions. Kind of to preserve the court's time, I'm not planning to go through all of this, but out of the 10 the 10 misdemeanor convictions, 6 of them have had either probation violations or community corrections violations. The 10 felony convictions, 7 of them have had some sort of violation, whether that's through probation or community corrections. Most recent, it looks like there was a community corrections violation in a 2019 case with us in Circuit 2. It looks like in 2019 there was a probation violation. So with the extensive history of just criminal history, and then with the extensive violation history, because it looks like the violation history has dated all the way back to 2005. So we have seen a consistent trend among many of cases that probation and community corrections just cannot be completed successfully, or there is some sort of violation in all these cases besides for a minor few. So with that being said, and then paired with the dealing allegations in this case, we often see cases of possession, smaller level dealings, but with a high level dealing, this does directly affect the community. This does affect Mr. Head himself and everyone around him. So with all that being said, I would be asking for the maximum to be executed with the violations of community corrections and probation. I don't see him as a fit candidate for either of the two programs. So I would be asking for a denial to community corrections.
Mr. Harlan.
Judge, first of all, I guess I would like to have, of course, swear in Brandon. I'd like to ask him some questions and let him address the court here, please.
Okay, now we get conflicted, guys.
Mr. Head, raise your hand. Solemnly swear or affirm under the public purchase testimony of this truth. Thank you, sir.
Brandon, can you state your name for the court, please? Brandon Lee. You're the, excuse me, the defendant, the accused in this case, is that correct? Yes, sir. All right. And obviously you've been in court 4 times and you'd like to be in court, right? On this matter and other matters, right? All right. And I think you have some family. I think you told me that your girlfriend's in the audience today. Is that correct? So you do have some family support, correct? I know your sister has been active in supporting you as well, but you told me earlier, I think she's sick and not able to come today. Otherwise, I suspect she probably would have been here in your court, right? Yes, sir. So despite the fact you've been convicted of various offenses here, you still have people that believe in you and want the best for you, right? You're not, when you get out, you're not a lone wolf. You're not having to do it all on your own. You got people there that are going to help you and encourage you and point in the right direction. You've been in jail just about 3 actual years, right? Yes, sir. Tell Judge Jacobs what you've learned about Brandon Head and what you need to do to go forward so you're not in cup suits or even
Judge Jacobs Jingleheimer Smith.
Or here where you're doing trustee work. What have you learned?
Your Honor.
Absolutely.
Your Honor, I messed up. I'm not denying that, but I can understand the state, how they see it on paper. It's bad. 59 charges it got me, but that's not me, Your Honor. I've had problems. I mean, the day I got arrested, before then, I was supplying my habit. I was getting high. When you see me in your courtroom, it was like possession. Nothing major. Now, no excuse for my mom, dad. I went a different way. That's no excuse. I'm owning up. I'm taking acceptance. Like I messed up. But since I've been in here, I've been a trustee for a whole year. No write-ups, no nothing. I've been also, I just want you to know all this, I've gotten accepted to CCATs for 2.5 years. I'm in a matrix PTSD class, drug class. I've been done with that for 3 or 4 months, but I still go. I've got my OSHA since I've been in here. I completed construction. I have my Ivy Tech. I did everything because I wanted to make myself better. And I want to continue to do better because that's not me from 3 years ago. And I just I mean, I've gotten accepted to rehab and I know it's probably no option, but I got a brand new one I just want you to know about from Miss Sharon and the, the Fresh Start Recovery. I've gotten accepted to the Lighthouse 2 years ago. I got accepted to a lot of places, but I've been working with Thrive and everything. I'm keeping to myself in here, no trouble, but yeah, I would love for the courts to give me one chance, but if I have to go to prison, Your Honor, I would hopefully want RWI. I mean, I've been 3 years in county and I'm not that person, Your Honor. I don't know how much I can say. It wasn't me 3 years. That's not me. I messed up. I did what I did. I'm not saying I didn't, but I think I have more to life than to what I got arrested for. I got kids, stuff too, and I'm trying to be a dad, a productive member in the society. Like, I know I can. I would ask courts for a chance, but I mean, I understand what the state is saying. They got a job to do. I can't be mad at nobody but myself, but that's not me, Your Honor.
Brendan, you said you've been a trustee for about a year. What sort of jobs or positions have you had in the jail as a trustee?
I've done everything. I worked in the kitchen, fresh favorites, and now I'm a janitor. I mean, anything they need, I'll do. I'm just trying to stay productive while I'm in here.
And in a lot of those positions as a trustee, you have the ability to go various places in the jail kind of unaccompanied, right? You don't have a jail guard with you when you're going to do your maintenance work, or when you're going to the kitchen or something like that, right?
No, sir, I got leeway.
Right. They unlock your cell and you go and do what you needed to do, right?
Yes, sir.
And return when you were supposed to and so forth.
Yes, sir. No write-ups in jail at all. Nothing.
And no new cases in jail.
No.
Which I know that's, people would expect that shouldn't happen, but we know that those things happen in jail. What's your sobriety date?
Oh, I've been sober since I've been in jail. The day I got locked up, I was high, I don't remember, but since then, coming to jail, I've not touched nothing, not been around nothing, and it's my first time in a long time being sober this long.
Good job. You said you had children. How old are your children?
I got a little girl that's 5 and my son just turned 19.
And when you were out of jail, were you interacting with them? Did you have a relationship with them?
Yes, sir.
All right. That's your plan to do when you get out of jail, right?
Yes, sir.
All right. And you have other family here. I know you have a girlfriend, a sister. I know your mom had passed. You have other families that live here in the local area?
Yeah, my whole family's around here.
Okay. So again, when you get out, you have, like say, you have that support system of people there. What's your aspiration? I know we've talked about it before, but I don't know if Judge Jacob said, ever heard of what do you want to do to support yourself and your family when you get out? What's your goal?
Well, since I did construction, I have the cards in my property, but like the OSHA card and everything. So I learned about that. But since I've been in here and I've been talking to Thrive, I also, knowing what I know now about everything, I want to do something like that to help. I mean, being in this side, you feel me? I mean, on this end, and when I get out, I think I have some knowledge, if I put it to use, to help people. Do something like that. I've been talking to John a lot, and I'm ready, Your Honor, like, for a change. I mean, come in this courtroom for years, getting high is not fun no more, Your Honor. And I'm sober right now, so I plan on staying sober. I know it's harder out there than in here. I understand that. I plan on staying sober and doing for my family, being there for my kids, being a father that I know I can be.
Brandon, at the time you were arrested, would you say you had a drug addiction issue?
Yes, sir. I honestly don't remember.
How long has that been going on in his life? I mean, that probably isn't something that happened, started a week before you were arrested, right?
I've been using drugs for,
Dude, this dude has said every single thing that makes me say, oh, yo, let him go. Let him go. He's fine.
20 years.
Various varieties? All
Yes,
drugs?
yes, sir.
Okay. Alcohol been an issue for you or not?
Not really.
Okay.
My brother died from alcohol, so I really did.
That's it. Okay. So you still believe that you need help with your recovery to be going forward, right? Even though you're clean now, you understand that life is different outside, and that's what you just said.
Yes, sir.
So you'd still like to work toward RWI for you to continue on your recovery process?
Yes, sir.
I don't know what he did, but it wasn't good. It was pretty bad.
Whenever I do get out, I plan on going to sober living somewhere first. I'm not just gonna step, you know what I mean, right out, and I plan on getting in sober living and still doing the steps. I never did that. I've been,
You can't
and
have
I know what
sex.
she said, the violations, but when I did have probation, either I would, I guess, fail a drug test and I'll serve it out. But I never really had the steps. I never really had to do them. And now I've been doing the steps in here. I'm learning. I know more now.
Anything else you want to tell Judge Jacobs?
I'm ready for a change, Your Honor.
Yeah, you can't have sex in a monastery.
I
That
just
was
want
in the
to
80s.
reiterate, that wasn't me 3 years ago when they arrested. I don't remember.
Maria,
Like, I'm not making no excuses. I did what I did. I'm owning up to it, but I would want a chance, or like I said, at least RWI. I mean, I'm probably going to prison, so I just, not, since I've been here 3 years, get out just so I can do better. Keep doing the steps that I'm doing. I know I can do better, Your Honor. I know that wasn't me. I got more to life than to be locked up.
And just kind of echoing what Brandon has said, I think there's a lot of factors, a lot of mitigating factors. The state, I think, expressed the aggravating factors, and we're all aware of those, mainly his prior record. I would note that when I was looking to the PSI, that though he's had 10 felony convictions, there were 2 cases that had 3 felonies each. So there weren't 10 separate events of felonies. But as is often happens in this court, people have offers where they're pleading to multiple felonies from the same event. So I'd like to point that out. So the felony level is not quite as significant as it sounds on its face. He has been a trustee for a year. CCATS has said, hey, you are eligible, both because of his expressed need and their analysis that he needs help with his sobriety, but also the fact that they believe that program would be beneficial to him, getting him where he needs to be. As he indicated, he's given me a number of certificates of things he's completed. He's completed the Matrix Substance Use Recovery. In fact, he's completed that a couple of times. The OSHA 10 recovery, the soft skills credential. He has also completed the manufacturing course through Ivy Tech, and also the IKORCC course, as well as an addiction recovery program in the jail and seeking safety. And I think he's told you that he's also working on a Matrix PTSD program now, right?
Yes, that's what one of
That's
them
one
was.
of them.
I'm still going to the class.
All right.
But I remember certificates like 3 or 4 months ago.
Okay. And he's continued to try and work on his recovery through what he's taking in the jail, through working with Thrive, through actually getting places to be able to go for recovery. And he's right that I have some acceptance letters for Salvation Army and the Lighthouse, and most recently acceptance letter dated just January 23rd of this year to
Come on, guys. He's done a lot. He's done a lot more than we've seen. He's done really, really good. He's been in prison for 3 years already. Sorry. He's been in jail for 3 years. Not prison.
the Fresh Start Recovery, which is a program over in Louisville. So I think we can see his motivation, his work as a trustee, that truly he is a different person than he was 3 years ago. And Judge, I know you've seen him in your court before. You've seen who he was before, and I think you're seeing who he is today. And the court certainly will take that knowledge that you have of having had Brandon in your court previously in other matters when you craft a sentence here. We understand this is probably not the kind of case where the court is going to probate the remainder of the time. And Brandon and I have talked about the fact that he most likely will be going to prison, and he's expressed that. So we're certainly expecting that. Now, obviously, we would not be upset if the court didn't do that, but we understand that situation. He does have 3 years, just about 3 years in jail, so it's equivalent of about a 4-year sentence, executed sentence. Plus, he has some time cuts, and the court will tell us what that number is. I never know quite how much the court provides, but it sounds like anywhere from 6, maybe 4 to 6 to 8 months of time cuts there, which may be close to another year of executed time. So, Judge, we would ask, as the PSI recommends, the advisory sentence 17 and a half years. I understand there is aggravating circumstances that the state has given, but I think Mr. Head has given the court some pretty mighty mitigating factors in terms of his work at the jail, the programs he's completed, the goals he has in life, the family support that he has out there, the fact he's accepted responsibility. The court's aware we were running up to a trial, and Brandon reached out to me, I think, after we had a hearing with regard to what items of the videos would be redacted. And he contacted me by church and said, hey, is there any way we can work out a deal? I'm ready to get this done and accept responsibility. So he's done that. So that would have been certainly a very long and tedious and tiring trial for everyone involved, for the witnesses, the court, the prosecutor, myself, obviously for Brandon as well. So I think that acceptance of responsibility is something else, mitigator, that should put the court in that position of saying, okay, I'll sentence at the advisory 17 and a half years. We've asked the court to suspend a significant amount of that to give him time when he gets out of jail, say 10 years of that suspended.
He didn't commit 59 murders. He committed 59 other crimes. Just, possession and things like that.
The remainder, obviously, in DOC, give him RWI and the opportunity to ask the court to modify the sentence upon completion of that program, which is really the next step in his recovery. Because I know we all want Brandon to be well. We want him to be a bigger or a better Brandon Head when he gets out of jail when this case is done and finished. So that'd be a request, Your Honor. Thank you.
All right, definitely started. Mr. Head, the court's going to recognize the mitigator, the aggravators that are criminal issues. Obviously, we can't get past that. Mitigators that you do, obviously, substance disorder as well. That screams out at me because I'm looking at that, and that you did plead guilty without the benefits. It's an agreement. Now that's reduced a little bit because we were on the verge of trial. We all heard some of the testimony that was going to be pretty damning at trial, so I don't really get a lot of choice at that stage. However, it is the mitigator. I'm going to find the aggravators outweigh the mitigators, but I think you're going to be okay with where I landed. I'm going to go backward from the little ones. The count 42, the C misdemeanor, 60 days fully executed. Count 41, the B misdemeanor, 180 days fully executed. Counts 29, 30, 33, 36, 39, all level 6 felonies, 1 year, all fully executed. Those are all executed and concurrent with one another.
Just so you know, they were level 6 felonies. That is the lowest felony you can get.
Count 28, level 6 felony, 1 year executed. Count 25, 5-year felony, 3 years executed. Count 22, the 4-year felony, 6 years executed. Again, all executed, all concurrent with everything. So none of that matters. The two, count 1A, count 2, both are level 2 felonies. I'm going to sentence you on each of those for 20 years. 15 years to be executed, 5 suspended probation. I'm going to order RWI, but can't order that you're eligible for RWI. Now, I think that undermines everything that we're doing in the community in general. You've got to have some accountability. So I'm going to order you're eligible to start RWI after serving 6 actual years without your arrest. You've got 3 more to do before you can think about RWI. I was going to say 7 years. I wrote 7 years when I realized they may not take into account time cuts you're going to get, and they actually just do calendar. So after you serve 6 actual years from the date of your arrest, you can petition, apply, whatever it is, to do the RWI program. Finish the program and file a petition to modify your sentence. And if we do that, when the cash programs go up the road, it probably is, that might be your next step down. Finishing the RWI program does not mean you get out of jail. It might mean I just knock 6 months or a year off of your sentence on the back end. That's the end of it. It probably means we bring you back home few years early and said to put you in the cash program, let you work on all the stuff you need so it's a smooth transition into never get in trouble again. But finishing the RWI doesn't mean you're going to get out right away. So I don't know what will happen then. Hopefully I'm still here in 3 more years. But the state has an opportunity to object. The state may even call witnesses and put on your PSI and have other people testify on things that you've done, a reason that I shouldn't grant the modification. So I don't want you to bank on that to guarantee. It's probably a good outcome if you finish the RWI program and we'll transition you somewhere soon. But I don't know where that's going to be. Mitch has submitted 1,500 or 1,052 days, so we'll give you credit for 1,052 days. This is a final appealable order. You can talk to Mitch about whether or not you want to file that appeal. That's something that requires to represent you and all that, and what that might do to modification of the future and whatever else. Talk to Mitch about that.
The credit for the courses.
90 days for any or all or one of the OSHA classes and the trades classes. You get 30 days for any wellness classes, any mental health classes, matrix, or any of those. You can't double on those. So you only get 190 and 130. You can't do anything.
So 120.
Yeah, max.
Okay. And Judge, when you said 6 actual years, obviously we know he has about 3.
Yeah.
Would that include the 120 days you just gave?
That's why I
part
did like 7, because I don't think they would. I'm writing you're eligible after 6 to begin the program. So the order, to make the order where it does incorporate that, I made it 6 instead of 7.
Okay.
I don't think so. I think it's going to be 6 years, 6 actual years from your date of arrest. So I think they're in with the calendar, not taking the correct calendar.
So 2028, you'd be eligible to start the start of WI. We'll work with it as well.
All right, Mr. Head, then you got to file that petition, because that doesn't have automatic.
Yeah, I told him I would do it for him, Judge, if he gets older,
Okay.
if I'm still around.
And I've never heard anybody say anything bad about it. I've never heard any of the police officers say that you're a bad guy, you can go away from it. They're out to stop you from breaking the law, and they wanted to arrest and they wanted to prosecute it. But none of the detectives who worked this case told me you're bad. So
Nice. I mean, not nice, but nice.
They got you out of this one. All right, what do you say?
So he's going to prison. I wouldn't have sent him to prison. I'm just saying, I would not have sent that man to prison. But he's going to prison for a while. He has to do at least 3 more years before he can even start the process of getting out. And it's not like on parole. He's not allowed to get on parole. He has to go to that WI whatever program, and you're still locked up, but you're not in prison. You're in a home. You're locked up in there, and then eventually you can work up to getting a job, and you can go out to get a job, and then eventually you can get like a weekend here and there with family. But yeah, he did a lot though. We see these people who don't do anything at all, not even the slightest. And I see court cases where people in jail get more and more charges every day. I show some of them. And he's been a trustee for a year now. Let's see, okay. So, I didn't get this whole trial. So where we're starting at, we're starting in the middle of a sentence. where when this defendant was on the stand, which we don't see, he had said that her arm, the victim's arm got broken because she was trying to hit him and he put his arm up in defense. She broke her own arm. She broke her own arm when she was trying to hit him and he just put his arm up in defense. So that's where we're at in the middle of this sentence.
Broke when he raised his own arm in self-defense, and when they met, that caused it to snap. Then he says he ran the victim over, ran over her ankle because she dove out, but he didn't bother giving aid right then. He had to drive around the block. But not to worry, he was devastated about the experience, or so he told probation. Not to be outdone, he then professes his love for the victim, expresses his confusion as to why she would say things like this, and then calls her a liar. He cloaks himself in this image of a loving person who deeply cares for the victim and worked hard to keep the relationship going. But really, it was all about her mental health issues. He then just refused to discuss anything about the violation of protection order, but he does say he's being punished far too harshly and that he was forced into this situation here today. These are the statements of a well-seasoned manipulator, Your Honor, who cannot and will not take responsibility for his actions. It's worth to note that he has completed domestic violence treatment in the past. He has completed court order treatment for, I believe, it was a DWAI, as well as DV classes and his other DV convictions. Not sure if that's because he just white-knuckled his way through that, but clearly those that did not take. His prior convictions, Your Honor, at least as it relates to DVs, there is a pattern, a history of violence and violence against women. In the 2008 M753, he strangled his wife, pushed and pulled her hair, bit her, disconnected 911, and then when she called for help, he immediately fled. In the 13 M724, fortunately that was too old, we could not get any reports. In 20 M342, the son had to call because he was assaulting his mother, and then at which point he struck the son. All of these with his previous wife, the same victim, Your Honor. Again, a pattern. So who is Mr. Vigil? Well, what we know is that he had no childhood trauma, no physical, mental, or sexual abuse. He said his household was happy and normal. We know he has a supportive family relationship and lifelong local friends here in the Valley. And he holds a high school degree. Does not have any mental health conditions or substance abuse issues. And he has successfully completed treatment before. He is unlike a lot of people that come through these doors, Your Honor. A lot of folks come through and their actions are at least understandable because of an addiction, because of poverty, because of mental health issues. For instance, an individual may trespass in the middle of winter to stay warm, who's homeless. It's still a crime, but we understand it. There is mercy for things like this. His violence, his abuse towards others is his and his alone. It is not contributable to anything else. We have the results on the LSI as well as the DVSI. He's in the maximum range, Your Honor. He's going to reoffend again. He's a high-risk domestic violence offender. And the next time he stands before this court, it will not be for a misdemeanor DV offense, or even an assault too. It'll be for an assault in the first degree, an attempted murder, or God help us, a completed murder. Let's talk about guilty conscience for a moment. Why tamper with your victim? Why would someone tell a victim to lie about what happened to law enforcement and the prosecution? Why would you tell them to say it's made up, or that you don't remember anything? Why say that a warrant will simply go away? Why profess love and a possibility of a future, then why try to guilt them into saying that they're responsible for sending him to prison and to think about his kids? There's a short video with, I'm sorry, a short audio recording with the victim, which led to the people filing forfeiture by wrongdoing. Because my concern is that, you know, he's trying to tamper with you, or he's trying to prevent you.
Drive me. I don't know. The whole thing is just really fucked up. I just can't go to this trial. It's just everything is, you know. And yes, he's contacted me. I'm not responding anymore. So
Because yeah, my worry is that, you know, he has ever threatened you or told you to, you know, to lie or not tell the truth on the stand, or to not come here and testify.
yes, he has. Like, he hasn't told me, like, he's like, don't, he's like, he's even said, don't, a warrant's nothing. It'll just go away. Like, that's what he told me.
Oh, you mean if I, oh, sorry, go ahead.
If I were subpoenaed and I don't go, he's like, oh, I'm like, they'll issue a warrant for me, not if I don't go and do this. And he's like, oh, a warrant will just go away, Christy. I'm like, no, it doesn't. So he tries all of that. And, you know, my counselor's like, do not even talk to him anymore.
Oh, wow. So he's told you, don't show up, a warrant isn't that big of a deal, just don't come testify.
Right.
He looks familiar, though I doubt we've
The only
seen him before.
inescapable conclusion, Your Honor, is that he did this with a guilty conscience, showing his guilt, and even buttressing this victim's statements as being more truthful. This court found a forfeiture by wrongdoing. This doctrine is older than the founding of our country, and it exists so that a defendant cannot reap a benefit from his own wrongdoing when he removes evidence from the criminal justice system. It is no small thing for a court of law to extinguish a defendant's constitutional rights, but it was the correct and the just decision. The court found that he was responsible for procuring the unavailability of the victim, and that he had the specific intent to deprive the criminal justice system of evidence, which he absolutely did. This, in and of itself, is an aggravating circumstance, but that's not all. There was a statement the defendant made at the plea hearing that's quite telling. He said, I should have just taken the misdemeanor. This previous offer, so the court knows, was a dismissal or non-filing of the felony habitual DV in the violation of protection order, and a misto assault 3 plea with DV probation on the felony. This offer was given because the victim had disappeared. He couldn't find her. He was counting on this. This is why he waited and waited and waited and didn't want to take a plea. He was playing a game to see how long the prosecution could go before it was forced to dismiss the case. He had the victim wrapped around his finger and knew that a dismissal was the only option if we couldn't find her. That's why he gave her money. That's why he messaged her with thoughts of love, which slowly turned into manipulation, guilt tripping, and gaslighting, because he knew he was losing her and things were going worse for him in court. Of course, he knows how the criminal justice system works, specifically how it relates to domestic violence. This is his 4th conviction.
We love to see it happen. We love it.
For it. He knows how hard it is to go to trial without a victim and that it will dismiss the case. You can see it. He stuck to his story so strongly on initial contact. He denied everything. He locked down his story. He was slowly and carefully removing evidence that could be used against him in an effort to get the case dismissed. He took the medical records, wouldn't let her get the tissues, evidence of crimes. He played a game, Your Honor, and he lost. Even now, here today, he won't take responsibility. He blames the victims, gaslights, deflects, dodges, manipulates. We've tried probation, didn't work. We tried treatment in classes. Clearly that doesn't work. We've even tried court protection orders, and that doesn't work. This is not someone that is suffering from a defect or a disorder
Did you try to take away his cell phone?
or an addiction. This is not someone that cannot control his action or understand the ramifications of them. He is smart, he is controlling, and he's manipulative. It is beyond clear in his attempts to manipulate the victim, the prosecution, the courts, and the evidence, and only a lengthy prison sentence will satisfy the purposes of sentencing in this case. He could have killed Miss Loomis that night by watching her bleed to death if she didn't agree to lie. The next time he comes back here, it'll be for a more violent crime. He has shown zero remorse for his victim, has taken zero responsibility for his actions, and shown zero respect for court orders, the victim, and the criminal justice system. So for the charges of domestic violence, assault in the second degree, serious bodily injury as a crime of violence, the people asked the court sentence the defendant to the Department of Corrections for no less than 12 years. On the violation of protection order charge, Your Honor, you may be inclined to give a lighter sentence on this one, because if you look at it just solely as the violation of protection order, it is just a couple of likes. It's just a couple of thumbs up, but it's so much more than that. It is a habitual domestic violence offender. We've heard about his prior domestic violence, and we've seen how they have evolved over time to become more violent and more sophisticated. After all, in his first domestic violence, he decided to disconnect the 911 line, showing a desire to avoid consequences for his actions, and then fled the scene, something of which is sort of universally known as a sign of guilt. And now look where he's gotten. He's created alibis. He's falsified timelines. He's removed medical evidence. He's tampered with the victim. This is someone whose criminalistic behaviors have evolved, Your Honor, and they will only continue to. This case, Your Honor, is the cycle of control and violence in its purest, most unadulterated form.
Okay, guys. Sarah just gifted 5 memberships, and she got someone named Chica Chickenhead. Oh, Chica, please come into chat. We need to talk to Chica Chickenhead.
Has to be stopped. The spokes of the wheel must be knocked out, or it will only get worse. For the charges of violation of protection order as a habitual domestic violence offender, people asked for no less than 2 years Department of Corrections to be consecutive as mandated by law and agreed upon the parties. Thank you.
Any restitution or cost of prosecution in these matters?
Your Honor, there is an open CVC claim. We do not have that number yet, so we would ask to have restitution reserved.
And which case is that on, please?
That is on the assault case, Your Honor.
Chica,
So 23.
Yes, Your Honor, 131.
Thank you. Mr. O'Connor.
Your Honor, first of all, I think we submitted a number of letters to the court.
And I did have a chance to review those. I think there was one from defendant's stepfather, his mother, his ex-wife, Justin Rivera, and Todd Middleton, correct?
At least that many, Your Honor. I think we submitted.
And I recall receiving one from his son, but I don't see it up. There's a couple more I see there. So I have read them as they've come in as well, and then reviewed them for today's hearing.
Your Honor, there are a number of people here today in support of Mr. Vigil. I'm going to have a couple of them speak.
Okay, and that's fine. Who would you like to speak first?
Sure.
Mel, there's the chicken skirts. There they are. I want some chicken so bad.
And so your name is Nathan Vigil?
Yes.
All right. What would you like to say, sir?
First off, thank you for letting me speak on behalf of my brother. My brother, everyone has problems, but he is a very good man. He's always been there for me, taught me a lot in my career as an electrician, and shows a lot of dedication in what he does and pride in it. Everybody makes mistakes, I get that, and I'm just here to basically ask for some kind of leniency on him. My parents are in their older age. My mother's 70, recently had a stroke. lost control of her arm, and things are getting a lot more difficult in taking care of her by myself. Recently, I have an accident, and just trying to take care of her daily needs has become more difficult. And I was hoping that maybe some way I could get him out of Eagle County to Pueblo with my parents and maybe give him some kind of different rehab or a lighter sentence to help us down there. He's recently a grandfather, has I think a 1.5 year old grandchild, and I know he would love the opportunity to be better for them and for his kids and for his grandchild. And I'd hope you just hopefully give him another chance to maybe get out of here and better his life somewhere else.
Well, thank you.
Thank you very much for the time.
Mr. O'Connor? Yes, sir. Your name?
My name is Justin Beal.
Yes.
My dad, Stephen. It's been my dad for about 25 years of life. And he's not a bad man. I understand what the evidence is pointing for him. He's raised me to have respect. He's raised me to have integrity. You know, and I believe solely on rehabilitation. I don't think locking him in the cell is going to do him no good. He's a man of many talents. He's an electrician. He's a trucker. He can do anything. If you called him at 2 a.m. tonight and said your water line broke, he'd be the first one there to help you, you know? And I'm all for paying for a long patient rehab out of my pocket to keep him out of the prison system, you know, and if he messes up in rehab, I support you guys locking him up, but I think he deserves another chance, you know? I know, you know, he has a past my mother and I have, but you know, he's changed and I've seen him change, you know, and he struggles with alcohol. I know, no, the DA doesn't believe that he has a problem. Yeah, he does have a problem with drinking, and that stems to what's going on here today. You know, we all make bad decisions when we drink too much, and I feel like rehabilitation will do him better than locking himself for 12 to 14 years, you know, and we're losing a good man that can help me raise my kids and show my kids how to ride a bike. And it's just unfortunate, you know, I'm not here to change your mind, but it's unfortunate, you know, that my kids won't get to know their grandfather until they're over the age of, you know, 15, 16, 18. So, you know, I hope you take it into consideration. He is a good man. He's not this animal that you guys are making him out to see. And
he beat him when he
I
was
think,
younger.
like I said, I'm 100% willing to pay for his rehabilitation for 6 months, a year, however long you think he needs to go, but I don't think prison's the way for him. And I appreciate you for giving me the time to talk on my dad's behalf. And I know you'll make the right choice you feel like is needed.
All right. Thank you.
Thank you.
Mr. O'Connor?
Keep him
Yes, sir.
away from your
name, please?
kids.
Samuel Matthews.
Yes, sir.
Oh, I've met Stephen before. In these situations, it seems the mental wellness of the victim has not come into play. Understanding that this man is extremely patient with this woman. She actually has a lot more problems. She's been kicked out of numerous places, has gotten in many fights.
And
This
Mr.
man,
Matthews, I apologize for interrupting. I just want you to frame your statements. Trying to blame Miss Loomis for what has occurred is not going to be supportive of Mr. Vihill's cause. So I just want to point that out to you.
okay, I was not blaming her. I apologize. I was expressing the comparison of the mental issues that we've been hearing. In comparison, again, Mr. Vihill is very patient. The sentencing is extravagant. As far as the 12 years for the situation from the proof that we have seen. If there is a way for him to go into psychological rehab, that, as we know, is usually better for individuals compared to.
Excuse me, sir. If it was the victim's fault, why does he need to go into psychological rehab?
being locked away without considerable assistance with their issues and what they're struggling with. I am here to just state and plea that you take into consideration, what if it was your son, and what would you want him to do to get help? You know the system, and with that, I will thank you for your time.
Thank you. Mr. O'Connor? Your name, sir?
Good morning, Your Honor. My name is David Heredia. I'm a business owner. I own and operate Copper's Electrical Service here in the Valley. I work on high-end smart homes. Steve worked for me for quite a few years, and he was in charge of, he would run certain projects for me. He's very talented in that area with electricity. I know Steven. In the time that I've known him, he's always just been Steven. I've never seen this side of him. I know.
One good thing is coming out of these comments, guys. Steven is sitting there thinking, oh man, these are great comments. The judge is going to believe them. He's thinking right now, he's got a chance.
I know that he's made a mistake in this instance. I'm asking for leniency. His mom's obviously in a bad place, and she's going to need him more than ever. I come from a bad area. I come from the hood, and I pulled myself out of there. I didn't return. I've seen a lot of this, and I know that being incarcerated just makes my opinion and what I've seen in the past, what I've witnessed, doesn't make for a better person being incarcerated. I really believe that he needs in-depth treatment with alcohol and management. I've seen that work, versus incarceration. I'm asking for leniency in this case.
All right.
And
Thank you.
that's all I have to say.
Thank you. Mr. O'Connor?
Yes. Honor.
Good morning, Mr. Rivera. What would you like to say?
My name is Justin Rivera. I have employed Steve for the past 6 or 7 years. I don't really know what to say because I'm not trained in this profession to convince people in any way, shape, or form how to do things when it comes to your job. So I just want to tell you from my heart how it is I dealt with Steve more than probably anybody in this room, and I'm lonely without him. I miss him. We all need him. I don't really know what to say. Like I said, I'm not trained for this. I believe what is going on here is a little harsh for what is going on. I have heard this gentleman's ridiculous statements in my eyes about numerous things. I have heard many conversations between Stephen and the alleged victim. I just think it's unfair. That's all I can say. As far as the sentence, I and everybody in this room feel like we would do anything possible to keep him out of taxpayers paying for him to go sit on his butt and do nothing when he needs to be working and paying his own way and learning from his mistakes. And that would be working, paying off, paying this, paying that, instead of us as taxpayers paying all the things that are going to be useless in my eyes. So I appreciate your time, and I pray that you can find forgiveness in this man, just like everybody else has. And we all deserve more than just a second chance.
All right. Thank you.
Thank you.
Mr. O'Connor? One more? Thank you. Your name, ma'am? Yes, Ms. Vincent, what would you like to say?
Well, I've known Steve for, a good part of my life. He actually used to date my sister. And I can tell you firsthand what a wonderful relationship they had for numerous years. And he's been part of my family for so long and spent holidays with us, went on vacations with us. And the love that he has shown my family, my kids, myself, he's a completely different man than what the prosecution painted. And when he got involved with Christy, I can't begin to tell you how different the two of them were with one another. And it changed him. And obviously, with what the court saw, it's not the Steve everyone knew and everyone loved. They were just completely toxic for one another on both sides. And the entire time they were together, we literally begged Steve to please stop being with her, get away from her. And I may be throwing myself under the bus, but that's quite normal. I actually got into a fight with Steve, a physical fight, because of Christy. And Christy came over Steve and fought me because of it as well. So Christy is not innocent by any means. She is a fighter. She is a...
So when you say you got into a physical fight with him, what you really mean is he hit you. He hit you too.
vicious little fighter as well. And I think that also proves what his friends and family will do for Steve. I personally I would fight for Steve to get him away from her because of the type of individual she is. And, but in my eyes, this really isn't about who she is. It's about who he is as a man and the potential he still has in his life. And he's not going to reach that if it's behind bars.
Creme brulee, iced coffee today. Iced, not even hot. I could not drink hot coffee today. I can't tell you why, but a lot of you ladies know. I could not drink anything hot today. So I got 4 creme brulee iced coffees, and they are freaking delicious.
He has so many friends and family that showed up for him today. And he has a grandkid that needs him, and he has his kids and his family and friends here. And he's not going to be able to be around them if he's locked up. If the state and you could please take that into consideration and find it in your heart to please not just lock him up, but to please find a rehab facility for him that will actually help him instead of just tossing him away like the criminal that the prosecution painted. I know you're just doing your job, but it really wasn't that great. But maybe not just listen to how Christy painted him, because she's a really bad person. and they were just terrible together. And it's not just oil and water, it's a chemical
Oh,
that
please
just
stop.
erupts together.
Go away.
And he deserves so much better in this life than what they were together. And he is a loving, caring, heart of gold man. And he deserves better than to be put away for the next decade or 2 decades, whatever he's facing. And I really, really ask that you find it in your heart to please give him some leniency and not just what was painted in this brief time that he was with a very terrible woman that brought out the worst in him. Because I know that he has the potential, and I know that he was an amazing, amazing human when he's with the right people. He just fell
This is the sister of his last girlfriend or wife. I don't know. His last relationship.
down, and he just needs to be picked back up again. And with the support system that he has with us, I know that he can get there again. So I ask that you please give him that chance.
Thank you.
Thank you.
Mr. O'Connor.
Yeah, he hit her.
Your Honor, this has to be one of the hardest and most frustrating cases I think I've been involved with. This happened almost 2 years ago, over a year and a half ago. And as stated by the prosecution, the original offer in this case was for a misdemeanor plea and probation. There's a lot of things I disagree with the presentation that was made, but to say the reason that offer was made because they couldn't find the witness just can't be true. I know they staff these cases with their whole office when they come like this. And all the facts that you have seen were present for the district attorney to make that decision. They knew she had a broken nose. They knew of his criminal history, and yet they offered him a misdemeanor plea. I talked to Miss Loomis numerous
Don't
times
forget the broken arm,
when
sir.
this case first
The arm
started.
broke.
And she really
Ankles
didn't have any
broke.
interest in going forward. I didn't ask her to do anything other than, can you notify the DA's office and let them know how you feel about the case? And that went on for a long time. Ultimately, we know Mr. Vigil made a poor decision by not accepting that. I think everything was not driven by what the district attorney is painting, that was trying to get out of everything. I think he truly loved this woman. Did that show that he loved her in those pictures? No. And I don't want to stand here and try to argue with everything that you saw, but some of the conclusions
Nothing shows love like blood pouring out of your nose.
that came from that, I don't believe are correct at all. So Stephen has had problems in the past, but this is a first felony conviction.
I don't remember.
He's
I'm
been
sorry.
through treatment before, he's been on probation before, and he successfully completed all of those. They weren't things that he just shrugged off. He has been
He learned a lot.
vigilant in the past of doing
Vigilant.
that. What do I think happened that night? I think it was something that was fueled by alcohol. And I think Mr. Vigil will tell you the same thing. I don't want the court to think that he is not taking responsibility for what happened. He pled guilty to these charges, knowing what the punishment that he's facing is. I've come to know Stephen because I've spent a lot of time with him over the last year and a half. He's always been straightforward with me. He's always made his court appearances. I think he's always, when he's in front of the court, has been courteous to the court. I know in his mind, he wished that this night had never happened. But Your Honor, what they're asking for as punishment in this case far exceeds what I think he deserves to have happen. I think the presumptive range on this charge is 2 to 8 years. So I think the midpoint of that would be 5 years. And Your Honor, that's what we are going to be asking for, is a 5-year sentence. On the second charge, I think you've seen from the evidence that was produced, what he did was send an emoji to the victim. There was no direct communication. It was that he liked some posting that came up. And we know that this has to be consecutive. We'd ask for a 1-year sentence on that, Your Honor.
All right, thank you.
Thank you, Your Honor.
And Mr. O'Connor, I believe probation calculated 49 days credit.
That's correct.
Sound right? All right. Mr. Vigil, anything you would like to say prior to sentencing?
Oh, he's gonna talk, guys. Don't hit me. Just talk over there.
Just that I take all responsibility for my actions today. This got blown totally out of proportion. I'm
There were
sorry for any
broken bones.
pain or anguish I've caused to Miss Loomis, to my family. I wish I could rewind back a year and a half, 2 years, but I can't. And I apologize for everything that has happened, everything that's transpired. I take full responsibility. I just ask that you might have a little sympathy on my life. I have a lot more to offer my children. I just rekindled a relationship with my daughter after not speaking with her for about 2 years. My mother needs me. My dads need me. And I have a lot more to give than what I gave. I've been selfish. I was in a dark place after my divorce. And I just hope you might see that my heart is true and I deserve a chance to end my last decade or two of my life.
He hasn't spoken to his daughter in a while, and he just reunited with her. Gee, I wonder why. I wonder why he hasn't spoken to her in a while.
In peace.
All right, thank you. All right, so in this matter, the court did have an opportunity to review the pre-sentence investigation report, review the criminal history of the defendant, read the statements, also did read the letters provided by the support system. Heard the statements today from Nathan and Dustin Vigil, Samuel Matthews, Nikki Vincent, as well as Justin Rivera. And honestly, Mr. Vigil, I don't disagree. Treatment is the preferred way to approach this. Looking at your criminal history, this started in 1988 when you faced DUI. You received alcohol treatment at that point. We then moved to 2008. I believe that might have been your first conviction for domestic violence against your wife, then wife. Again, supervised probation, treatment. We have a conviction in 2013, another conviction for domestic violence. Again, supervised probation, treatment, random testing, alcohol-related treatment. You had another driving alcohol offense in 2015, again, treatment, supervised probation. We then moved to 2020, another domestic violence conviction, supervised probation, treatment, alcohol testing, on and on. I don't disagree with what your support system says, but you have to actually make these decisions. You had control. In all of these instances, you had support, you had that in place, and you could have taken advantage of it to change your trajectory. You could have changed the place you are now had you taken advantage of that. The other thing I think is important is all these folks want to support you, think you can do well. I wish they had. I wish something had happened, an intervention had occurred, and I didn't have to worry about you reaching out to try and kill Miss Loomis, or break her nose again, or break her arm again, or do the things you have done again. Because some of the stuff that wasn't charged is your ongoing contacts with Miss Loomis, your ongoing attempts to get her to absence herself from these proceedings. This is domestic violence, and only you can stop your behaviors. I believe everybody that spoke on your behalf. I believe they very much think you can do better, but you're actually going to have to do it. You have to do it. You're the only one. You're the only one that can change it. And Miss Loomis, whether she is a terrible human being or not, she did not deserve to have her nose broken or her arm broken, and she cannot change your behaviors. You do that. In this matter, you are going to prison. The second-degree assault is a crime of violence because of the serious bodily injury, and that is a 5-year minimum mandatory sentence. So in 23 CR 131, what I am willing to do is just order that 5-year Department of Corrections sentence with 3 years of mandatory parole and 49 days credit. In that case, there is a $100 fine, $163 victims compensation fee, $163 victims assistance fee, $40 in court costs, $2.50 genetic testing surcharge, $10 restorative justice surcharge, and Mr. O'Connor, you're appointed, correct?
Correct. Yeah.
$25 public defender fee. No restitution requested, none is ordered. Victims' Rights Amendment was complied with. In 24 CR 97, that is the felony domestic violence based on the violation of protection order. And something I think is somewhat important is that you bonded out in 23 CR 131 on May 17th, 2023 at 3:30 p.m. The charges in 24 CR 97, the date of offense is May 18th of 2023. You didn't make it even 24 hours after being ordered by the court to stay away from Miss Loomis. That in so many ways illustrates the pattern that continues. And that's what has to be addressed. So at some point, the scales tip. It's no longer about how we can help you, but how we can protect other people from you. And that's what these sentences intend to do. Absolutely. Whoever told me that this is not how you rehabilitate people was absolutely correct, but that's not really my intention now. My intention now is to protect anyone you might choose to date from you, because it's not just Miss Loomis, but your ex-wife also was a victim. So it's not just one person and one person's behavior. So everyone's being protected from you for this time frame. So in 24 CR 97, you were on felony bond when that occurred. There was a protection order in place when that occurred. The court is going to order a 3-year Department of Corrections sentence that must by statute run consecutive. So that's a total of 8 years. On that charge, there is 2 years of mandatory parole. Again, because I've given you the full credit on the first sentence, no credit on that, that will be a full 3 years. On that case, there is a $100 fine, $163 victims compensation fee, $163 victims assistance fee, $40 in court costs, $2.50 genetic testing surcharge, $10 restorative justice surcharge, $25 public defender fee. The temporary protection orders in these cases run for the full term of the sentence. That means there is a protection order protecting Ms. Loomis for at least the next 8 years, but it will run the full term of parole as well. Do you have any questions?
I love that $2.50.
Mr. O'Connor, anything else?
Your Honor, I mean, just a slight correction. He was
Yep.
not on felony bond at the time. It was charged as a misdemeanor.
Misdemeanor bond then,
It was on,
but nevertheless, bond protection order in place, correct?
correct.
All right, thank you. Anything else from the people?
No, Your Honor, thank you.
All right, Mr. Vigil, I do hope you can get something out of this, but again, the purpose isn't necessarily that. Take care, sir. Thank you.
But he has a year of credit, I think, or 100 days. One of those two. I don't really listen. At the end, when they talk about the sentence, I don't really listen. I should start listening. So I did not get Judge Fleischer today. I got a portion of it, but it's still trying to save right now as we're sitting here. But we only went through a little bit from yesterday. So we're gonna finish out with Judge Fleischer. Yeah, I got everything done. I think we were about, did we do him? I do not remember. Hi, Kim. Kim's here, guys. Okay, I have this great friend named Kim from New Zealand. All right? And I remember talking to her one day, and people from New Zealand do not say deck. They do not ask you to come over and sit on their deck. Just know that. If you're ever talking to someone from New Zealand and they say something very inappropriate to you, they're saying, come sit on my deck. All right, guys? This is life lessons that I'm teaching you here so that you don't fall into the same issue that I did. I think we did him. So, yeah, we did him. Oh gosh, if there's not more people, it's going to be a early day, guys. It's going to be an early day.
Rivas.
Mr. Rivas also has a felony. That case was dismissed today, so we just have our misdemeanors now.
What am I supposed to do, Mr. Rivas? Over and over and over. I ordered you not to use any illegal substances, and yet it continues to happen. No, I mean, what? Alicia, when was the first test that we did on Mr. Rivas?
My last test was the test I took.
Did you represent him on the aggravated assault?
No, I didn't, Judge. He was just appointed an attorney this morning up there, and the case was dismissed the same day that he was appointed an attorney. Who was the attorney appointed?
Mr. Andrew Williams.
Andrew Williams. But I'm sure you know what he's going to say. He said he was trying to explain to you that the marijuana was in his system from when he was arrested.
Everybody stop talking about decks. Nan's here. Wait, one more. Hi, Nan.
On January 22nd. Yeah.
Judge, the only test we have is from the 18th.
What day? You mean today?
No, the 18th. February 18th.
Okay, that's.
I just took a test last week. That was my
And that's
first
what
test.
the,
You've been on bond in this case since September. Since September, you've known not to use any illegal substances. It's now February. What possible excuse could there be?
There is no excuse, Judge, given that.
He has 3 open cases with us. I mean, I've continually told you not to use.
Right. I think one of those cases was possession of marijuana. He said that's the day that he used, the day that he was arrested for possession of marijuana.
September 28th.
Yeah.
Sorry,
Fishnet deck.
goes with you. I don't know what to tell you, Mr. Rivas. You're not getting it. I'm telling you, no using.
Can you give me another chance? My first says this Friday I have a college for UTI, which I paid $200 for. I can show you proof. I have an email of UTI. I've been changed. I've been trying to change. I told the judge upstairs too. I haven't smoked since I got out. I'm an ankle monitor. I haven't smoked since I got put in this ankle monitor, Judge. You can.
When you get that ankle monitor?
Took me on the day I got released from jail.
Whenever he checked in for the drug test on the 18th, he did state to us that it.
You got the ankle monitor on the 18th? So you tell me you stopped smoking 2 days ago?
No.
Sorry, that's when he told us he had consumed marijuana in about 2 to 3 weeks from the 18th. And then the ankle.
So 2 to 3 weeks ago, you're telling me he says he stopped?
No, I stopped since I got out of jail.
January 22nd, Judge.
That's the day I stopped. I enrolled in college now, which I paid $200.
That was the last arrest because these cases were
If
different.
it's January 22nd, it's been 1, 2, 3.
Guys, how many times are you all gonna do this? Toll Monkey does not start a new job tomorrow. Toll Monkey was saying he was about to say he's starting a new job. Come on, guys.
4 weeks and 3 days, 4 days.
Judge, but I know I can change. Judge. I've been trying to better myself since I got put in this ankle monitor. I've been in jail.
I'm only blaming you guys because I always do it. Hey, all right, congratulations. It's usually me.
I don't want to be.
Yes, it's from January 27th or January 28th.
January, what day exactly?
They entered it on the 28th, but I don't believe he got it until the.
Decks make your head
Sorry,
all
they entered it on the
fuzzy.
27th. I don't believe he got it.
What was the absolute last day?
The day I got arrested for the aggravated for this charge, this case that I got dismissed, I was parked in the car. That's when it happened. That's the last time I
That's
smoked.
December 19th, I see as the date of arrest. Or you tell me the time you stopped was the time they put the ankle monitor on you?
So
Tell me, Mr. Clay.
the December 19th is when that felony was filed. He wasn't arrested on that felony until January 22nd. And he's
Okay.
saying that's the last time he smoked. When he got out on bond for that case was January 27th. He was given an ankle monitor as part of
Yes,
the
he was
felony
given an
release.
ankle monitor in the jail on the 27th.
And I haven't smoked ever since. I'm trying to change.
All right, then I'm going to give you the benefit of the doubt. Then I'm going to calculate it from the 27th and on to give you the benefit of the doubt. I will test you again 40 days from that day, 45 days. If I find that you test positive again for marijuana, it's not going to go well for you. If you're lying to me, it's not going to go well. Do you understand?
Yes, sir.
Do not use. Do not hang around with people who are using, because I don't give a rat's behind if you tell me you're in a car and everybody else is hotboxing it. I don't care. Do you understand?
Yes, sir.
If you're really working this hard to better your life, which is really commendable, right?
I just got a job. Now I just enrolled into UTI, which I had proof my Gmail.
Hey, so did Toll Monkey. Maybe you guys work together.
Which is this Friday. I have a touring class, and then I have in tour in the.
Then don't muck it up by hanging with the wrong people. I bet all the cases that you have now. You speak Spanish?
Yes, sir.
Dime con quién andas, yo te digo quién eres. Do you understand?
Yes, sir.
All right, Felicia, we know what it is. Okay? All right,
All
Mr.
right,
Leggett.
Judge.
All right, man. Make me proud. I'm not asking for much. Don't use, but don't put yourself into a position when you're hanging around with bad folk.
Yes, sir.
All right.
Thank you.
Judge, your fabulous coordinator, NCLO, answered all the questions.
He's working it up. They
That was
do
a
the
close
county
one.
to schedule and I'm trying to move it up once it has to be, so we're good.
Okay,
Thank you, Judge.
Michael Fan, come on.
Mr. Pelani, G-H-A-N-I.
Come on up, Mr. Ghani. Man, 12:30 already? Mr. Ghani, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. It's actually
Yeah,
a DWI
JK,
second that's being
I
reduced to a
figured.
first. So that's 2 DWIs on your record. What happens on the next
Where
one?
is the library? Yes, I got that one.
Nope. Again.
Prison.
Right. Do you have any clue what they would do to you in prison? I've read stuff it'll turn you white. It's so bad. I read that had you freaking tears because it's so bad. That's how bad it is. Really. There's some parts of the
He read my paycheck.
prison, they're so bad that jailers won't even go into it because it's so bad. That's how bad it is. And all you need is just to have the faintest smell of alcohol, because when you get pulled over next time, because it's going to happen, officers, all they look at is your record. And if they see your record and they smell even the faintest smell, you understand. If I were you, even if you've had a sip of alcohol, I would never get into a car. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, it can never change this. Do you understand? For you to complete this successfully, it is 1 year in Harris County Jail to be probated for 18 months. You must do a repeat offender DWI education class. 2 victim impact panels. You will also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them. Substance abuse treatment. No drugs, alcohol, guardian interlock, 25 hours of community service, and a $100 donation to the Houston Area Women's Center. Is this how you understand the agreement?
Yes.
There are literally more drugs in most restaurant kitchens than there are in pharmacies.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this probation and once you plead guilty, it will go on your record. It will be there for the rest of your life. Do you understand? There's also a no breath test refusal clause as well, meaning that if you're pulled over in a car, an officer asks you to submit a breath test, you must do it. If you don't, you're in violation of this probation. Do you understand? There is a supervisory fee that you will be required to pay with regard to this. And if you don't pay it, you will sit 1 day in jail for every $100 you owe. Because it's a 0.15 or above, it is a $4,500 surcharge that you're going to be required to pay. And if you don't pay it, you'll be sitting in jail for a long time. Do you understand? All right, sir, I'm going to follow the agreement, sentence you to it. Good luck to you.
Your Honor, with the court consider waiving his fees, he's lost his job. His mom was the one that was paying.
I don't know that for sure. All I know, it's a DWI second. I mean, we warned him. So, I mean, I'm going to give you enough time to pay. Okay. We will give you 2 years to pay. You know, it's never about the money as far as probation is concerned, though. You know, if you ever have problems, come back, we can talk to you. But you must get a job. I don't know, you know. I mean, I can have you fill out an affidavit. We'll see what your financial situation is, but I want you to pay the fee. You know, I want you to learn so you don't pick up another one. I have someone that's sitting in there right now. Same thing. They're sitting out $6,000 something dollars, you know? It's not a joke. Take it seriously. Do you understand? All right. Good luck.
Thank you, Your Honor. I also have a motion to withdraw Mr. Nathan Fuller, Your Honor. He's a bond forfeiture.
Say it again.
I have a motion to withdraw from Mr. Nathan Fuller.
Okay.
Whose paper?
I see it.
I haven't heard from him, Your Honor.
Was he required to be here today?
Yes, Your Honor.
Okay. I'll grant it and then I'll revoke it.
Thank you, Your Honor.
Okay. Thanks, Michael.
I got the phone the sheriff's about Thomas.
Oh, they know. She knows.
Okay.
Hi,
I confirmed. It was 100 a day.
Yeah. So what she's going to do is what's smart is they're going to move their TRAS up so you can get the TRAS done now because it takes a while to get felony TRAS done because they're so booked up, you know. So on Fuller, top of page 6, 5,001.
5,000.
Yeah. Counsel, are you ready? Come on up.
Sorry, I have one more motion to sub,
Okay.
and then the second one has a piece I rolled over from yesterday, Crystal Gonzalez.
Okay.
We were getting the piece in, the client, she's here, she did send me everything. This is my email, it includes 9 reference letters, so I'm asking for just review 1 or 2 days so I can make sure I review everything that she sent me and send it to the prosecutor.
Okay. You want to roll till Thursday?
Yes, sir.
Okay. I'm okay with it.
Does she have to come on Thursday? She's here.
If everything's not submitted, you know, I mean, what's the last name again?
Gonzalez.
The case is old, right?
I believe.
Yeah, it's 215 days old. The problem is the only way we get stuff done is by actually getting people in here to do stuff, right? That's why. So, I mean, so it's it done or is it not done?
It's done. Like I said, it has like 9 letters and some more information in it. So I just wanted to review it all. And the last thing it needs is to be notarized, which will be done today.
Okay. If it's completely submitted, like actually submitted to them,
Yes, sir.
then I'll waive it.
Okay.
But if it's not actually submitted, then she's got to be here.
Yes, sir. Understood.
Okay. All right.
Thank you.
Sure. Counsel.
No, sir.
You with them?
All right.
This is a motion. Okay.
I did enjoy your talk at the CLE.
Sorry?
I enjoyed your talk at the CLE this weekend.
Oh.
I was there at lunch.
Thanks.
So, do you think his talk at the CLE was recorded? What is the CLE? All right, let's just look real quick. Let's take a field trip. Clerk's office. CLE. I don't know what CLE stands for. And oh wait. No, I mean CLE. All right, hold on. Nothing's coming up for CLE. Nothing is coming up. I'm going to look at chat. Maybe chat will have an idea. Ready? Here we go. I'm going to look at chat. Continuing legal education. You guys are so smart. Jen Hardy. No, it's not recorded. Boo. Boo. They didn't post it, so we can't hear his talk. Peg Leg did cheat. I mean, he's a lawyer.
It's interesting to hear from a lot of other, you know, I think it's great. It's really cool. I enjoyed it too. Come up, Mr. Merritt. Mr. Merritt, come on up. Did you get the cause number for this, Alex?
No, Judge.
Tell me when you're ready.
All right.
254-7447.
I believe he's actually a lawyer. Except for that typo.
Mr. Merritt,
there.
you were
No,
charged
he's
with
not a
criminal
lawyer.
trespass.
Yeah, no, I didn't know. I didn't know what you did. I went down there to where I go to the medical Costa de Amigo, and I got there early.
Hold on. You have the right to remain silent. You have the right to remain silent.
Yeah.
Exercise that
Okay,
right.
okay.
Because I don't want you to say something that's going to hurt your case.
Yes.
Okay? All I know is that your bond is at $5,002 because you've missed court a couple times. But we're glad that you're here now. You need a hearing aid, man. I don't know how much louder I can talk.
I can't hardly hear at all.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Okay.
Would you like me to appoint you a lawyer? You need one. Is that okay?
I didn't know I was even breaking the law.
Well, let's see. Please.
Yes, Judge.
Speak loud.
Yes, Judge. On January 13th, 2025, at 814 Crosby Street, the Boys and Girls Club, the complainant stated he has asked the defendant to leave 10 times in the past, and officers have warned the defendant to leave the property in the past as well. The defendant refused to leave the property after being told multiple times on January 13th. The complainant called the police, and the officer observed the defendant on the property and detained him.
Was it that one day he was there?
He was there on the 13th of January, and the complainant said that they had warned him 10 times in the past not to return to that location.
Okay. Mr. Merritt, I'm going to find that there's probable cause to go forward with your case. Do not go back to the board. What is it?
I don't go back over there. As soon as they did that, they've never told me nothing. The only reason I go there is for medical help.
Okay. You're going to have to find a new place.
Somebody lying right there.
Okay. Perhaps
Said that.
like LBJ Hospital or something of this
Okay.
nature. I will give you a lawyer today.
I'll tell you what, believe me.
I
don't need any kind of trouble.
Please. I'm going to have to reset your case to give you time to work it out with your lawyer. Okay? I'm going to need you to come back at least one more time so you guys can talk about it.
Okay. Good.
Okay? So if you just want to take a seat, I'll have you speak to a lawyer here momentarily.
Sure.
Okay?
Come up to where?
I'll have a lawyer talk to you.
Sure.
Okay. Please.
But I'll get my own lawyer pass.
Let me give you one.
Yes, sir.
Judge, are we reinstating the bonds? Yes, Judge.
Can you appoint, please? Wait, he still couldn't hear me.
My kids.
And there are no returning to that Boys and Girls Club.
Please.
Yes, Judge.
Yeah. So please remain still.
Yes.
That's based on conditions?
States.
Okay.
We'll go through the list. You don't have to call me.
Princess Diana said it was going to withdraw.
What?
Princess Diana. That's his email.
Friends, I know that's so funny, isn't it? I mean, is that his dog?
Yeah.
That's so
I asked
funny.
him.
5,001 on that one.
Next is, oh, page 10 and 11. Booker was supposed to approach you on that one. He left and didn't come.
Nah. But SFBF tomorrow.
Next judge is. Oh, that's it.
All right, we're done.
For this one, Judge, when.
Anybody out there?
No. Some conditions, I think, for married. You don't have them? When council shows up for the one I just appointed, how much time do you want to give?
However much you want. Don't matter.
Fine, it's fine. It's almost 2 hours. It's all good. I just wish there was a little bit more. My son did that to me one time. She told me he was bringing a girl over. He told her I was hard of hearing. He told me she was a little slow. So she spoke really slow and really loud to me. And I believed him. I It didn't last long. It only lasted for a few minutes before he told us both what idiots we were. But you know, that's my son for you. He definitely takes after his mother. All right, I'm going to set up OJ. I didn't set up OJ yet. I should have. I know. So nothing is going to pop you right over there. I just need a minute to set it up, and then we'll get started. Thank you so much for coming out, guys. I really appreciate it. I'll see you all again soon. I'm thinking of a members only today. I don't know. Her docket starts at 1:30 Colorado time, so 2:30 Eastern Standard Time. So it won't be until later if there is one, but I'm not gonna cut into American Courts time. So it will not be later than 8 o'clock unless I miss it completely. Then it'll be way after 8 o'clock. It might not even be members only. If it's funny but not really bad, then it'll be a public one. If it's bad because it's the mental health docket, then it'll just be members only. If it's members only, though, I think we should play a game. If it's members only, because I can't play this game on the public one because I'm going to be hitting all kinds of copyright issues. But let's play Name That Tune. So I'm going to have videos that you can't see off the screen. And I'm going to play just like a note or two of them and then pause it. Yeah, Mel, what is the time frame of this again? Okay, her docket starts at 1:30 Colorado time. Mountain? I don't know. What is Colorado? Where's Otto? Otto, help. And it's a docket, so it's probably over at, 5 o'clock. Okay, so I'll tell you right now. If it's going to happen, it's going to happen in approximately 12 hours from now or 11 hours from now. How's that? 11 to 12 hours from now. Unless I'm going to bump up against Bill. I don't want to bump up against American Courts. That's just mean. But I think we should play a game. I wonder if I should just set it for after bells, so it'll be late. Hi, Walter. That way we have as much time as we want to play. We can keep playing forever. That's a better idea. As soon as American Courts is over, if I'm going to do a members only or another stream, it'll be as soon as American Courts is over if he streams tonight. Which is in 13 hours from now, his stream starts. Ish. None of that made any sense. Listen, there might be a stream later. Much later. There might not. We'll see. We'll see what happens. If there is, and it's members only, we're going to play a game. And it's going to be fun. Alright. Thanks, guys. Thanks for coming out. I'll see you in OJ. I don't know, Val. That's the best I can do. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. Wicked stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh